Welcome back to the deep dive. Ever wondered what actually protects the vital systems that keep our modern lives humming? Imagine your power grid collapsing, maybe your internet going dark, or clean water suddenly running dry. Sounds like something out of a disaster movie, doesn't it? But these are real threats, and today we're taking a deep dive into the legislation designed to prevent them, South Africa's Critical Infrastructure Protection Act of 2019. Our mission today is to really unpack this consolidated act. We'll explore its core purpose, key provisions, and, how it actually impacts your daily life. Whether you're just curious about how society safeguards itself, or maybe you're a law student looking for clarity on this crucial framework, we're going to unpack its legal context, practical implications, and share some surprising insights along the way. Okay, let's get into it. Who's responsible when the lights go out, and what systems are truly in place to prevent that from happening?
Well, yeah, this act is a really monumental shift. It changes how a country identifies, protects, and makes its critical assets resilient against, well, a whole spectrum of threats. It's really about securing the very backbone of society and the economy, moving beyond just reacting to problems towards a truly proactive, holistic protection framework.
So why did South Africa need a completely new act for this? What was the driving force behind the Critical Infrastructure Protection Act of 2019?
What's fascinating here, I think, is that the Act's foundation is explicitly linked right back to the Constitution. It reinforces the government's duty to ensure the well-being of its people. The old legislation, the National Key Points Act of 1980, it had become pretty outdated, frankly, and it was often criticized for its lack of transparency, its sort of subjective criteria. This new act marks a really decisive move towards a more transparent system, something predictable, accountable. The aim is really to build public confidence in how these critical assets are secured. The core purpose is crystal clear. Protecting critical infrastructure is absolutely essential for public safety, national security, and, crucially, the continuous provision of basic public services. Think about it. A country just can't function if its essential services are compromised.
That makes a lot of sense. Moving from something perhaps a bit, opaque to a more open, modern approach, the Act really dives deep into its purpose. What are some of the key objectives it aims to achieve?
Well, beyond just protecting physical assets, the Act aims to secure critical infrastructure against a really diverse range of threats. We're talking about everything from criminal acts and terrorism to accidental failures and natural disasters. What's truly groundbreaking, I think, is how it explicitly recognizes that, say, a downed power grid from a flood is just as disruptive as one from sabotage. It's a much more holistic view of resilience. It also mandates objective criteria for identifying and declaring what actually is critical infrastructure. And crucially, it pushes for strong public-private cooperation. This marks a philosophical shift, really. It acknowledges that in today's interconnected world, governments can't secure the entire backbone of society alone. Private sector involvement isn't just helpful, it's essential.
Right. So it's all about protecting our essential services and ensuring everything keeps running smoothly. When we talk about basic public services and infrastructure, what exactly falls under those umbrellas?
The Act defines basic public service very broadly. It includes services related to communication, energy, health, sanitation, transport, and water. Doesn't matter if they're provided by public entities or private companies. The thinking is pretty simple. Any interference with these can severely harm people's livelihoods, their well-being, or just general economic activity. And infrastructure itself is equally broad. It covers any building, facility, pipeline, or system vital for society, government, or businesses like transport networks or the electricity grid.
So this isn't just about protecting government buildings, then. It's practically anything that's vital to daily life for you and me.
Exactly. And a key term that keeps coming up in the Act is resilience. It's not just about preventing an attack or a disruption, but it's about the infrastructure's ability to mitigate, absorb, or withstand damage, and then bounce back quickly to full functionality. It's about being able to recover and keep things going.
That's a crucial distinction. But an important clarification for our listeners, does this act apply to all infrastructure in South Africa? Is everything covered?
No, and that's an important detail. Section 3 specifically states it does not apply to infrastructure under the control of the Department of Defense. This just recognizes that military assets are handled under separate, specialized national security frameworks. Makes sense, really.
Okay. This sounds like a massive undertaking. Who are the main players involved in making this act work on the ground? Who's actually doing this stuff?
Right. There are three critical structures you need to know about. First, you have the Critical Infrastructure Council. This is a high-level advisory body. Its members are appointed by the minister responsible for policing. It's a really diverse group. It draws from various government departments, think defense, home affairs, state security, but significantly, it also includes 5 members from the private sector and civil society. These private sector appointees bring crucial expertise in areas like risk management, disaster management, and this is key, at least one person qualified in cybersecurity. That's a clear nod to modern threats.
Okay, so it's a blend of public and private expertise bringing together different perspectives. What does this council actually do, though?
Their functions are primarily strategic and oversight. They consider applications for critical infrastructure status and make recommendations to the minister. They also approve guidelines for how assets are risk assessed, categorized as low, medium, or high risk, and they promote that vital public-private cooperation we mentioned. They essentially set the strategic direction and advise the minister on policy and implementation.
Okay, so the council sets the strategic course, but we need someone on the ground making sure these plans are put into action, right? Enforcing things day to day. Who handles that?
That falls squarely to the National Commissioner of the South African Police Service, or SAPS as most people know it. Their functions are very hands-on, establishing administrative systems, supporting the council and the minister, fostering cooperation across government and the private sector, and developing uniform standards for how infrastructure is identified, categorized, and declared. They also conduct physical security assessments and compile regular reports. Very operational.
And then there are the boots on the ground, the inspectors. What's their role in all of this?
So under Section 10, the National Commissioner designates police officials, usually warrant officers with the right security clearance and experience as inspectors. Their job, as laid out in Section 11, is basically to conduct on-site inspections at critical infrastructure sites. They verify that security measures are being followed, they assess the physical security, and they ensure the person in control is taking all the necessary steps. They can even issue compliance notices if they find problems or, if they're denied access. And here's where the rubber really meets the road. If an inspector has reasonable grounds to believe a security failure poses a substantial risk of imminent disruption to the economy, law and order, basic services, or national security, the minister can actually step in and cause steps to be taken. In really urgent situations, the minister can even apply to a court to compel compliance. That's a pretty powerful intervention to protect what's vital.
Wow, yeah, that definitely highlights the seriousness of these threats. So how does an ordinary bridge or power station become officially labeled critical infrastructure? What's that journey like?
Well, the process, laid out in Chapter 3, is designed to be robust and objective. First, the infrastructure has to meet specific requirements for declaration. Section 16 covers this. It has to be genuinely essential for the economy, national security, public safety, and the continuous provision of basic public services. And the real kicker is that its loss, damage, or disruption must severely prejudice the functioning or stability of the republic, the public interest, or national security. It's not just important, it has to be critically important.
Right, so it's about the potential ripple effect if it were to fail. What kind of criteria are used to make that judgment?
They look at several criteria, things like its significant economic, public, social, or strategic importance, the potential impact on the country's ability to function, effects on health, safety, or even other connected infrastructure, whether the declaration genuinely promotes the public interest without significant negative side effects, and even international obligations South Africa might have.
Okay, once it meets those pretty high bars, how does the application process actually work? Who starts it?
An application can be lodged in 2 ways, according to Sections 17 and 18. Either by the person in control of the infrastructure, that's usually the owner or operator, or by the National Commissioner themselves, but specifically for government-owned infrastructure. The application requires really extensive details, so everything from the sector it operates in, the resources available for safeguarding and recovery, potential environmental or health impacts, the population at risk, historical threats, any unique characteristics. It's comprehensive.
And then this detailed application goes to the council you mentioned.
Yes, that's right. But first, the National Commissioner conducts a physical security assessment. Then, typically, a notice of the application gets published in the Government Gazette. That's the official publication for government announcements for public comment. Although there is a provision for secrecy if national security demands it, understandably. Only then does the Critical Infrastructure Council consider the application. They apply all those criteria we talked about, and they determine a risk category, low risk, medium risk, or high risk based on the probability and impact of potential threats. They then make a recommendation to the minister, always giving the person in control a chance to make representations first.
And the final decision ultimately rests with the minister then.
Correct. The minister, acting on the council's recommendation, formally declares the infrastructure as critical under Section 20. They assign its risk category low, medium, or high, and can impose specific conditions for its safeguarding. A formal certificate of declaration is issued, Section 21 covers this, detailing all these aspects, and the particulars are entered into a prescribed public register. Though sensitive security measures can be kept confidential if necessary for security reasons.
This all sounds very thorough, very structured, but what if things change? Can a declaration be amended or maybe even revoked?
Absolutely. Section 22 allows the minister to amend the risk categorization or the conditions if circumstances evolve. This would again involve input from the council or national commissioner, and importantly, they have to give the person in control notice and an opportunity to respond. And yes, a declaration can be terminated or revoked under Section 23. This might happen if, say, the infrastructure's activities cease, if the original declaration was found to be based on false information, or if the person in control consistently fails to comply with the Act's conditions. So it's definitely a living designation, not set in stone.
Okay, so once an infrastructure is officially declared critical, what are the key responsibilities for the person in charge, the owner or operator? What are they on the hook for?
Well, under Section 24, the person in control has a pretty significant duty. They have to take prescribed steps to secure the infrastructure, and generally this is at their own expense. For government infrastructure, this means protection must be provided by properly vetted employees, or, if that's not feasible, by an approved security service provider. But that at their own expense part can be a big deal, especially for private entities.
Yeah, at their own expense sounds like it could be a heavy financial responsibility. Is there any flexibility there at all?
That's a really important question. Well, the general rule is at their own expense. Section 24 includes a fascinating provision. The minister can, under specific circumstances, and after consulting with other relevant ministers or municipal councils, determine that a head of a government department is responsible for all or some of the expenses. This acknowledges the strategic importance and the potential cost burden, especially for state-owned or operated critical infrastructure. It ensures vital protection isn't neglected just because of budget constraints.
Okay, that makes sense. But what happens if the person in control simply doesn't comply with an order, if they just don't do what they're told?
The minister can issue a formal written notice, ordering them to take specific security steps within a set period. If they refuse or fail to comply, the minister has a pretty powerful recourse. They can actually take those steps themselves or cause them to be taken, and then recover the reasonable costs from the person in control.
Oof. Okay. That really underscores the importance placed on this protection, doesn't it?
It certainly does.
Are there specific roles or personnel mandated for security within a critical infrastructure site, like a specific job title?
Yes, absolutely. Section 24/7 mandates the appointment of a security manager. This person isn't just anyone. They must undergo rigorous security vetting by the state security agency. Their job is to implement and monitor security policies, authorize access, liaise with security providers, and report directly to the person in control. They're the central point person for security on site.
Got it. And what about access for the public? Or even just workers? What are the rules for entering a critical infrastructure site? I imagine it's not like walking into a shopping mall.
You're absolutely right. Access control is very strict under Section 25. The person in control must place clear notices at all entry points, stating that permission is required from the security manager or authorized personnel. Visitors may be required to furnish ID, declare any dangerous objects they might be carrying, and even subject themselves and their belongings to examination by electronic apparatus, think scanners, and metal detectors. Now, for individuals, searches are permitted, but there are strict rules regarding privacy and dignity. For example, any pat-down search must be conducted by a person of the same gender, preferably after informing the individual. And there needs to be reasonable suspicion that they're carrying a dangerous or prohibited object. It's all about balancing that security need with individual rights.
So definitely not a place for casual sightseeing. Are there any exceptions to these access restrictions, say for emergency services?
Yes, Section 13 clarifies this. Members of the security services, like the police or other government officials who have statutory powers of entry, think health inspectors or environmental officers perhaps, are exempt from these specific access restrictions when they're performing their official duties. However, they still need to produce proof of their appointment and identity to the satisfaction of the person in control or the security manager. It's about maintaining order and security, even for law enforcement or officials.
Right. Okay, this act sounds like it has some serious teeth when it comes to non-compliance.
Right.
What kind of offenses and penalties are we actually talking about here?
Ah, yes, Chapter 5. This is where it gets really interesting, especially for anyone uh, thinking about messing with critical infrastructure.
Mm-hmm.
The Act details a wide range of offenses under Section 26. For the general public, things like unlawfully sharing information about security measures if it's not already public domain, or taking photos or videos of security features, hindering officials performing their duties, unauthorized entry, or obviously damaging or threatening critical infrastructure.
Yeah.
These are all serious offenses.
And I assume the penalties reflect how serious these actions are.
Absolutely. A basic offense under Section 26, one say, hindering an official or unauthorized entry can lead to a fine or imprisonment for up to 3 years. But the penalties escalate dramatically if there's an intention to cause damage or substantial harm, or if actual damage occurs. For example, intentionally causing harm to a high-risk critical infrastructure can result in a hefty fine or imprisonment for up to 7 years.
What if the activity actually caused major damage or loss?
If the activity did cause damage, substantial harm, or loss of property, the penalties become even more severe. For high-risk critical infrastructure, this could mean a fine or imprisonment for up to 20 years. The risk categorization low, medium, or high directly impacts the potential sentence. It truly underscores the severity with which the law views these kinds of actions.
20 years. Okay, that is a powerful deterrent. What about the people in control of the infrastructure? Can they face penalties if they don't comply?
Yes, they certainly can. Persons in control can face charges for things like knowingly furnishing false information in an application, refusing to comply with an inspector's notice or the minister's orders, or maybe failing to put up those required public notices about access. These offenses carry penalties of a fine or imprisonment for up to 5 years, and for a corporate body, like a company operating the infrastructure, a fine not exceeding R10 million can be imposed.
Wow, our 10 million, that really emphasizes the corporate responsibility here. It's definitely not just a slap on the wrist. Okay, we mentioned earlier that this act replaces the old National Key Points Act from 1980. How does that transition actually happen, especially given there are existing national key points?
Right, the Act includes very important transitional arrangements in Section 30. It specifically repeals the old National Key Points Act of 1980 and related regional laws. Critically, any existing national key point is automatically deemed to be critical infrastructure under the new Act, but only temporarily. It holds that status until the minister makes a formal declaration under the new process we discussed.
So it's not an immediate switch off for those existing sites. There's a kind of grace period then.
Precisely. There's a defined period. The National Commissioner has 48 months, that's 4 years from the date the Act commences, to assess all those existing national key points and recommend their suitability for declaration under the new criteria. In the meantime, certain functions and powers from the old Act remain in force as long as they don't conflict with the new legislation. Importantly, though, new prosecutions won't happen for acts that wouldn't be an offense under this new Act. So there's some protection there during the transition. There's also a specific mandate for security service providers working at these deemed critical infrastructures they need to be properly vetted within just 3 months of the Act's commencement. This ensures consistent, high-level security standards right from the start of the transition.
We've truly taken a deep dive today into South Africa's Critical Infrastructure Protection Act of 2019, from its constitutional foundations, right down to the intricate details of who protects what, how they do it, and the really serious consequences for noncompliance. It's clear this is a very comprehensive piece of legislation designed really to safeguard our most vital systems.
Indeed it is. This act represents a significant evolution, I think, in how a country approaches its foundational security. It's a definite shift towards greater transparency, much more multi-stakeholder collaboration, and a really proactive stance on resilience. It moves beyond simply identifying potential targets to actually building comprehensive protection frameworks. And these frameworks involve both the public and private sectors, safeguarding the very essence of a functioning society.
And for you, our listener, whether you're a legal eagle, maybe a business leader, or just someone who relies on consistent electricity, water, and communication every day, understanding this act gives you a crucial insight into those often invisible layers of protection that keep our society functioning, hopefully smoothly. So what does this all really mean? I suppose this act is a constant dynamic balancing act, isn't it, between national security, public safety, and individual rights. It's a living document that requires ongoing vigilance and adaptation to, well, to evolving threats.
And that raises a really important question for all of us, I think. As technology continues to evolve at such an incredible pace, and threats become more sophisticated, think cyber threats, for example.
Yeah.
How do we ensure that legislation like this remains agile enough? Agile enough to effectively protect critical infrastructure without inadvertently infringing on the very freedoms and rights it aims to secure. It's a really complex challenge every modern society faces, and one that definitely requires continuous public and private sector engagement to get right.
That is a truly powerful thought to leave you with. Thank you so much for joining us for this deep dive. We hope you feel a little more well-informed about the critical infrastructure that surrounds you every day.